Mr. Price, we'll sit a quarter of an hour later to make up for the time lost this morning.
Grateful. I'd reached the section of the Court of Appeal's judgment in relation to section 4.1b. I've taken the court to paragraph 64 on page 289 of the bundle, the Economou case, what Mr. Justice Warby said in that, the precondition. I was going to move on to paragraph 66, which deals with the failure to contact the claimant. It said it's a basic requirement of fairness and responsible journalism that a person who is going to publish a story without being required to show that it's true should give the person who's the subject of the story the opportunity to put his side of the story. Of course, I accept as lawyers, it's bred in the bone for us that that's something that we should do. Fundamental part of the legal process, hear from both sides, except in unusual circumstances which are clearly defined. But I respectfully submit this is not a reason for imposing an analogous requirement on journalists in order to make good a Section 4 defence. It's not a requirement under the IPSO code. I accept the limitations of that possibly, but it's notable there's an obligation to take care not to publish inaccurate, misleading or distorted information. So the approach to the claimant not seen as a matter of fairness, and Section 4 isn't about fairness, it's about the public interest in reputations not being falsely debased and the public getting accurate information. So it feeds into that obligation, and that can be fact sensitive. I mean, the value of approaching a claimant to achieve such a purpose will vary depending on the circumstances. It was not fatal to Reynolds, the failure to contact. We've seen that. Shouldn't be treated in practice as fatal to a Section 4 defence unless there are some extreme mitigating circumstances. Parliament chose to remove whether the defendant sought the claimant's views on the subject before publishing it as a relevant factor in subsection 2, and instead require the court to consider all the circumstances of the case and make such allowance for editorial judgment as it considers appropriate. So the failure to contact, if it's unjustified, is a factor to put in the balance on the claimant's behalf, as was said by Sir Oliver Popperwell in GK Karate. This can be outweighed by the public interest in the free flow of information. And that was the language used by Sir Oliver Popperwell. I say that Section 4 is not a balancing exercise. It's an issue of evaluative fact as to whether the defendant's belief was reasonable, but one obviously can take this into account in determining the reasonableness of the belief, assuming it passes muster at the first hurdle, which is whether the information that has been acquired and the public interest purpose justify prima facie a reasonable belief that it is in the public interest to publish. Moving on to paragraph 70, this accepts that in rare circumstances it's possible for the public interest to succeed, notwithstanding that there wasn't an approach to the claimant. In my submission, given the flexibility of the test, it's not helpful to lay down sort of provisional views in general terms about whether the failure to do something should count so fundamentally against the defendant that the defence is lost. It's also to be noted that the judge accepted, we would say wrongly, that it is only in rare circumstances, unusual circumstances, where the defendant can be relieved of this obligation in order for the defence to succeed. But he held that on the circumstances of this case, that was justifiable, and that wasn't a perverse finding. The Court of Appeal really didn't understand the reasons that were given by the defendants, which I've tried to explain in Schedule B, their concerns about their sources and the long history of a failure to respond to publications, specifically about the takings of the Jazz Cafe, series of articles that have been published, letters from senior people within POSC. Neither POSC nor the claimant responded. The threats of violence, the concerns about the sources, all those things which seemingly the Court of Appeal didn't even take into account, but it's not a question of what the Court of Appeal took into account, really. It's what the judge took into account. He took it into account, and he reached a non-perverse conclusion that the defence shouldn't fail for that reason, which cannot be challenged in this court. There's a reference to Gatley, I think. Actually, that was in paragraph 66. Not generally a big fan of Gatley on the Defamation Act because, for example, it advocated the restrictive view of Section 1 that was rejected by the Supreme Court in Le Chaux, but actually it's quite equivocal on this subject. If you look at it, it's on page 2048. I don't see any need to go to it now. So I think, I've set out in Schedule A, in fact, to the case, the appellant's response to all the specific criticisms that were made in the Court of Appeal of their journalism and the judge's approach to it. I've also, in the light of the further criticisms that weren't made in the Court of Appeal but have been made in the respondent's case, submitted a chronology in dramatis personae which links into the witness statements and shows all the sources that they had. I think it's 5 or 6 employees from Colby House. I've made reference to an email where the information was first communicated to them, which was in the bundle in Polish at trial, it seems. But the translation had been provided, and if there were any primary findings of fact, evidence of primary fact as to what the defendants were told, then the claimant could have asked them about that at trial, but he didn't really challenge at all the primary facts that were set out in the witness statements that led them to believe that what they wrote was true, and for the judge to find that it was apparently credible. So I don't think that I need to go through that. So I think that's probably all I need to say in relation to Section 4. And then it's just nominal damages. And we've got the two routes to nominal damages, which is the judge was entitled to find the Jazz Cafe imputation proved. It's common ground that if he was entitled to award nominal damages. But it doesn't really matter in any event, because even if he wasn't entitled to find that imputation proved, all the other imputations that he did find proved, his general observations about the claimant's untrustworthiness, what happened with Mrs. Hadjuk at Colby House, the lies that were told in the witness box, all of that. And in fact, 13.6 alone, the stealing of investors' funds, would result in a non-perverse award of nominal damages. So the only thing I haven't made submissions on is the Jazz Cafe, which I think I can do pretty briefly. So this is a pure finding of fact with no evaluation in it at all. It's not a reasonable belief. It's just more probable than not that the claimant skimmed some of those profits from the Jazz Cafe. There's no issue about particularization. It doesn't complain that there had to be a specificity in exactly what he'd taken or when. If that argument had been made, it could have been rejected, but it's not made. So it's just whether it's on the material before the judge, he was entitled to find that it was more probable than not that the claimant had skimmed some of those profits. And of course, it's not an inquisition, it's an adversarial process. It's not a tryout on the road. It's the main event. And I don't know why the claimant wasn't represented at trial, but was represented in the Court of Appeal on a conditional fee basis. When he told the judge that the reason that he wasn't represented at trial was he couldn't find a barrister to act on a conditional fee basis. But that's, one has to be even more cautious in those circumstances of allowing points to be made in the Court of Appeal that could have been made at trial and weren't made at trial. And that's not only fair to the defendants and the judge, it's also fair to the defendant's witnesses. I mean, it's remarkable that the Court of Appeal felt able to say that Mr. Wegnowski and Mr. Pasker's evidence was not capable of belief. Mr. Pasker wasn't even cross-examined. Mr. Wegnowski was cross-examined. I don't know why we haven't got his cross-examination in the full bundle that has belatedly been put before the court by the appellants. I mean, we were told in a letter that the reason it wasn't obtained was because they accepted in the Court of Appeal that Mr. Wegnowski's evidence had to be taken at face value. It was put in a letter last week. But clearly, they weren't saying his evidence should be taken at face value. They were saying that his evidence could not be believed. So what's the principle on which the court operates in these situations of primary fact findings that are sought to be overturned? I mean, it's all very well to say it's a perversity test or the judge has misunderstood the evidence in some form of fundamental manner, but I think it's helpful perhaps to break it down a little bit into its elements. The starting point, I would suggest, is the evidence relied on by the defendant? We're saying this in the context of a defendant advancing a truth defence, so the person with the burden of proof is the defendant. So is the defendant's evidence to support the imputation capable of belief? That's the first question. And if it's capable of belief, is it capable of proving the imputation to be true? And if it is, and the claimant relies on evidence to rebut the imputation, is that evidence demonstrably true? And if it is demonstrably true, is it destructive of the case that is being put forward by the defendant? That should be the correct approach, and that wasn't the approach. It's really pretty straightforward. The judge was entitled to find the accounting systems at the Jazz Cafe were hopeless, essentially. There was a cash machine of a very basic kind, but there was evidence from numerous witnesses that when paying for drinks, cash was put into a box under the counter.
Have you got a list of those references? I mean, could we have a list?
Yes, most certainly.
So that we could just look at the
Yes.
evidence ourselves.
Yeah, I mean, the judge, I mean, of course I will provide that, but my primary submission is the judge made that finding.
Yes, indeed. I
And
understand the submission.
And although there's what I'm being faced with now is further challenges being made in the respondent's case, which if they'd been made in the Court of Appeal, I would have addressed in that section B. And of course, one of those is they challenge the suggestion that there were numerous witnesses who saw the claimant put money for drinks, cash into this box. Now the claimant says, well, yes, there was. He said at trial there was a box, but that box was the box supposedly at the end of the night when the bar closed. And he said he took the money out of the till and put it in a box, but that's not what the witnesses were saying. The witnesses were saying was, they were paying for drinks. It was going in this box. Well, why put it in the box? Now, whether that's enough on its own, one doesn't have to debate, because there was an admission to Mr. Wegnowski. And if one was subjecting this evidence to proper scrutiny by reference to a perversity test, the first question is, well, is Mr. Wegnowski's evidence capable of belief? Well, clearly it is.
Could you add in the reference, I'm sure we've got it somewhere, to that admission?
Yeah, it's page 508 in Core Volume 2.
Thank you.
Paragraph 33 of his witness statement.
580 is actually in Polish. It's
Core Volume 2, page 508?
Yes. It's in English. 508.
Or 508. I beg your
508. Tab 12.
Yep.
Paragraph 33, did you
Yes.
say?
No, yeah. I know this because Mr. Serafin used to brag to me about how much money he made from this situation when we started business in Polford. I'll just pause there because one of the points that's being made is, well, why would he go into business with this guy? Because he said he went into business because he thought he was trustworthy. That's a point belatedly raised in the respondent's notice, wasn't before the Court of Appeal. He's saying here, when we started business at Polford. Obviously, this is all without prejudice to the point that these points should have been made to Mr. Regnowski when he gave evidence. He would come over to my house for drinks and we would chat. He would say the jazz cafe is so good and how proud he is of good music there. Knowing him, I was surprised he was working there voluntarily. So immediately the context there is why he's doing it for nothing. He said that every Friday and Saturday night he would easily have made for himself around £300 to £400. He told me he was working with a friend. If this is about profit for the jazz cafe, or as opposed to personal profit, and that each of them would take a few £100s each weekend. So that, on its face, is an admission of personal profit. Now, I'm wary of arguing credibility points because I don't have to, and maybe there could have been some cross-examination in relation to that, which there wasn't, but the judge accepted the truth of that evidence, which he was plainly entitled to do. The claimant's account was, in his reply, that he had no such conversation with Mr. Regnowski about that. But when he was cross-examined, he suggested, oh, well, we talked about it, but it was about the profits of the cafe per se, not any personal profit on my account. But that's not how it appears.
Just give us the reference, please.
In the cross-examination?
Yeah.
Yes.
We won't turn it up, we just want to note it.
Yes. So it's it's page 660, and it's in core volume 2 at tab 17. It's transcript on the 30th of October 2017 at 67B.
Thank you.
So that's a credibility point against the claimant. I don't have to make credibility points against the claimant, but that's the evidence that was before the court. The judge found it convincing as to level of detail. He thought the relationship, the mention of a friend was relevant. I mean, whether or not that's unfair to Mr. Greliak's not really the point. The claimant was saying that he worked there with a whole lot of other people. The evidence was that it was managed between him and Mr. Greliak. So in those circumstances, it's quite relevant that he talks about a friend who also made money from it. And that was just a necessary part of the binary decision that the judge had to make as to whether this imputation was proved or not, whether it was more probable or not on the basis of the information before him that some skimming had taken place. So if you accept that those words were spoken by the claimant, as indeed you must, the next issue is whether that combined with the putting cash in a box and the obviously faulty system that was there is enough to prove that he was skimming profits, and clearly it is. The fact that he might have exaggerated the amount could be a factor against it being true, but it's not a killer point. And these points that are being raised, they're not killer points, and they have to be killer points, especially when they weren't raised at trial, and the judge has made a finding of primary fact. Then you get the final part of the equation, which is the evidence in rebuttal that's relied on by the claimant, and none of that is even arguably probative, let alone conclusive. And the judge was quite right or entitled to deal with it in the way that he did. It's strange that the Court of Appeal didn't think there was any credibility issues with Ms. Stenzel and Mr. Bajowski, I think his name was, because there were clear issues that emerged from the evidence which were recorded in the judgment. And all the references are set out in Schedule B to the appellant's case. I could make oral submissions on the new points that have been raised, but there really isn't time, and they shouldn't have been raised after the Court of hearing, and they shouldn't even be raised in the Court of Appeal, because as a matter of principle, this was not a tryout, this trial. The judge felt constrained to make this finding on the basis of the material before him, and he was perfectly entitled to do that. So if I'm right on that, we don't even have to worry about the impact of the other imputations in terms of nominal damages, because the respondent accepts that the Jazz Cafe would form a proper basis for an award of nominal damages. But even if you take the Jazz Cafe out of the equation, there is ample grounds for the reasons that I gave when I started this morning for an award of nominal damages. It certainly couldn't be said to be perverse. And I remind you that the issue is whether it would have been open to the judge to have awarded nominal damages if the Jazz Cafe imputation had not been proved. It's not whether he would have done or whether the Court of Appeal might have substituted an award. That's the only issue before the court. So if the court concludes that it was open to him to make that award subject to unfair trial, we're left with a nominal damages award and judgment for the claimant if the Section 4 defence fails, which it shouldn't do. But if it does, that's an outcome, as I said, that my clients would accept. So unless I can be of any further assistance, those are my submissions.
Thank you very much, Mr. Price. Yes, Mr. Metzer.
Thank you, Lord. And David. Can I say graciously, learned friends accept the 15 minutes, which you lost this morning. I'm going to
Yes, of course.
I'm conscious that I still don't have very long, but I was proposing to do
Can we swap,
Yes.
swap places?
Okay. Sorry. Thank you. Is that clearer?
Yes, that's fine, Mr. Metzer. Thank you.
Very much indeed, my lord. So what I was proposing to do was really to assist the court by saying where the passages are, what relevant material needs to be considered, and then, which I was hoping to assist, would be of greatest benefit. There are only 6 authorities actually that touch on the unfair trial point, of which only 2 or 3, I think, are of importance to the specific questions that need to be addressed. And I was going to prioritise my time in relation to the law, because I'm conscious, of course, that with the right of reply at the end, the points that are addressed by my learned friends can then hopefully more adequately be dealt with then.
Yes.
But can I respectfully remind the court that the appellant's case in relation to unfair trial can be summarised. It's taken quite shortly in relation to our case, paragraphs 73 to 86. That's at volume 1, tab E. See 178 of the bundle through to 181. So we have sought to deal with this in a relatively short manner because we respectfully submit the principles of law are unlikely to be contentious, but we respectfully submit there are some important aspects when one looks at the issue of unfairness of the trial to separate out, which we've sought to do, and we will intend to amplify a little bit about whether the trial judge's conduct was, if I can put it like that, put it as fairly as I think I can, ideal, or whether it was unfair. And I know that I can assume that the court will be thinking perhaps along those lines in relation to what side of the line it fell. We have...
Could you give me your page number again? I don't seem to be on it.
Oh, I'm sorry, my lord. It's in volume 1.
No, in the electronic number.
I'm sorry?
Electronic number.
Oh, electronically. Oh, yes, it's EB 78.
Thank you.
Through to EB 81.
Yeah, I misheard you.
No, I'm sorry, my lord. Thank you.
Thank you.
Schedule C, we have sought to deal with the points that have been advanced against us in relation to the conduct of the judge. And those have been set out. And Schedule C, my lord, is at EB 99 through to 106. We respectfully submit, with the greatest of respect to my learned friends, that's the material which it is quite proper and for us to seek to deal with, if I can put it like that, in relation to my learned friends' observations. We do note, and when one turns to the respondent's case, which is at tab F, and the area in relation to the unfair trial can be found at EB 13, it's paragraphs 134 to 147, which, for my lords and ladies' assistance, is at EB 155 through to 165. That's the material. In the course of that material, my learned friends have sought to add voluminous additional schedules, which is the material contained at schedules F and G, which can be found at 185 to 219. That's schedule F, and schedule G, and schedule F being what is described as adverse and unfair comments in the course of the trial in chronological order, a voluminous amount of material, and also in relation to Schedule G, words in the judgment evidencing hostility or bias, which is EB 221 through to 235. If necessary, and it may be not now, it may be in reply, of course I can deal with each and every one of these criticisms. But I have to say, alleged criticisms, we are concerned because this material, of course, was not material which was argued in relation to the Court of Appeal, and already Schedule C that we sought to introduce was in relation to the response that we expected to have to deal with from my learned friends. So there is clearly a considerable widening in relation to the material that the my learned friends seek to rely upon in pursuit of their submission that the trial was unfair.
I appreciate the point you're making. At the same time, I have to say I find it much easier to try to form an impression of whether the trial was fair or unfair by looking at the transcript fully rather than just the particular sentences that have been picked out as being evidence of bias or hostility.
Yes, my lord, if I respectfully agree, I can see exactly why that is, which is why indeed there's authorities, I shall take you to them, that support that proposition. It has to be looked at in the round as opposed to identifying and isolating. So, my lord, I wholly understand that. Can I make one observation before I really go to the meat of my submissions to you? The case now appears to be a much wider case before this court than is argued on behalf of the defendant before the Court of Appeal. It's notable in a number of regards in terms of the width of the allegations, or the way my learned friends now argue it, is not only wider but deeper in certain respects. And that is something that I hope, with the greatest of respect, I hope this court will be mindful of in relation to what is the appropriate way for this court to consider in relation to the conduct of the Court of Appeal in relation to their views in relation to the trial judge. And one notable admission that this court may consider is that the respondent, or the defendant I should say, has not put forward any evidence before the Court of Appeal, or for that matter here, but the Court of Appeal is really where we need to primarily focus, that the defendant himself, now defendant, the claimant in the original trial, was in any way the victim of an unfair trial. I mean, it's an extraordinary feature in this type of case, one would think, that there actually is no evidence to support the contention that this particular claimant, as he was the victim of unfair trial in any regard whatsoever. And why we say that is important is because when one does go to the authorities, one has to look at the conduct of the judge in relation to the way that he or she conducted the trial generally. And that absence of any evidence to support any propositions that my learned friends seek to argue in my respectful submission is of significance. The other point of significance in our respectful submission relates to, and I say this respectfully because I'm conscious that first of all I don't want to stray into giving evidence before this court, but of course I think I was the only counsel at the trial. And one thing that is absolutely clear from the trial, and indeed the authorities, and I shall take those to you in short form, is that the judge has to deal with the type of party that appears before him or her in each and every case. And I'm sure there will not be a misapprehension, and I say this very conscious that Mr. Serafin is here. This is not somebody, let alone, I shall go briefly, to the actual findings of Mr. Justice Jay in relation to the credibility of the former claimant. He, to use an expression, is no shrinking violet. Indeed, he's far worse than that, and I have to say this with the greatest of respect, that yes, of course, he was indeed a litigant in person, and one recognises readily the proper protections that should be available to someone in his position. But he, throughout this trial, exhibited nothing in our respectful submission that showed he was kowtowed by the judge, felt he could not present his case, was not permitted to cross-examine on witnesses.
Well, I may get a false impression from the transcript, but just to give an example, I was struck by his attempt to cross-examine Mr. Lozinski. Now, I appreciate Mr. Lozinski doesn't appear to have been the most crucial witness at the trial.
What page is this, Rob?
It's in the respondent's bundle, and the cross-examination begins at electronic 2517. That's what's printed on it, EB 2517. You might have the hard copy.
My bundle doesn't
Yes, I
have
have
it.
it. Maybe. It's the respondent's extra bundle.
Oh, hang on.
It's, I think, an additional bundle over and
Yes.
above the core bundles.
Yeah, that's
Yes. Maybe we have to revert to an earlier technology for.
I think we will. I won't be a moment.
Quite a thick bundle, headed. It says
I think it
respondent's
was
bundle.
provided a little after the main bundles.
Yes, that's it.
right. Yes, thank you. It never got sent electronically to me, but I'm not suggesting you didn't submit it.
Yes, my lord.
And you'll see on 2517, Mr. Serafin begins cross-examining the witness, Mr. Lozinski, who was, I think, one of a committee at POSC. And that carries on into the following page, and they get into an issue about whether Mrs. Serafin had been engaged to do work at POSC, and whether she'd been responsible for some slippery steps. And then we got on to the price at 2520, and then there are some questions about Maria Stencil halfway down 2520, and then the judge interrupts, saying that that is not a proper question. This is after the witness has said he didn't know what Mrs. Stencil looked like, and Mr. Serafin says, if I describe her how she looks like, you'll probably remember her better, maybe. She stated, and he gives obviously what's hearsay, and Mr. Justice Day interrupts quite understandably to say that's not a proper question. Then he carries on, as we can see, do not waste everybody's time, etc. Do not use it to make a speech. You were doing quite well until you insisted on ruining it by asking the wrong sort of questions. Mr. Serafin says, I think I finished because he don't know her. He doesn't know anything about Mrs. Stencil, so don't even go there. Mr. Serafin, there's no point. And that's the end of the cross. We weren't there, but reading the cold print, one might get the impression that the the cross-examination has effectively been halted by the judge.
Well, my lord, from the greatest respect, that's exactly what the other cases, authorities say is a danger by reading transcripts. As my lord rightly says, essentially we respectfully submit that what the High Court judge was doing was actually trying, it sounds strange, but actually trying to assist Mr. Serafin by saying, don't go down blind alleys that are irrelevant, not to the point, don't help your case. I mean, it's quite interesting when he actually says you were doing quite well and you insisted on ruining it. I mean, there was definitely a colloquial style at times that the judge used with Mr. Serafin. But Mr. Serafin, with the greatest respect, was perfectly able to give it back. There was absolutely no sense that he felt this is a judge intimidating him whatsoever. And the other observation I respectfully submit is, and this really takes on my lord's earlier point, and I do want to briefly go through the credibility findings, because this was not an important witness, and the judge made clear, if this had been a crucial bit of evidence that would have been determinative of an issue, I can see, with the greatest respect, much more force in the point. But actually, when the judge goes through the witnesses, and I'll just do that briefly, he does say which witnesses he believes and which ones he doesn't believe, but also, importantly, which witnesses he really doesn't, he actually says at one point in his judgment, as I'm sure the court has seen, most of the other witnesses I didn't really believe either sides. So this was not a situation of partisanship in terms of which witnesses he believed, where it was not across the board. So if I can briefly come back to that, my lord, very briefly. Can I say this, that the relevant parts, of course, of the Court of Appeal's judgment, returning to the core volume, volume 1, is, and it's quite short, considering how significant this is. I mean, the consequences of a ruling of an unfair trial, which is quite an exceptional situation for the people, really, with the points Mr. Price has already addressed you in relation to the draconian effects of ordering a retrial for my clients, would be readily apparent, given this was a fairly lengthy High Court trial. And one finds that straight away in relation to the Court of Appeal's judgment. It's CV 297, EB 297. It's really only paragraphs 103 to 119, so it's EB 297 through to 300. So, if I may say, a very short, particularly there's also a passage that's cited. It's quite a short finding in relation to a pretty dramatic aspect of the case. Now, there's nothing wrong, of course, in principle with doing something shortly. It's much to be commended. But in this case, in our respectful submission, one of the errors the Court of Appeal fell into was not only to find that this case fell on the wrong side in relation to fair or unfair judicial treatment, but there were relevant authorities, and two of which I'm going to spend a little time on, and I apologise for that, because I do think it will help the court. But, of course, the principles in Michel are accepted, but there are two cases that really would have been helpful if the Court of Appeal had considered in relation to their findings. But can I just take it very shortly in relation to what the Court of Appeal did find? At paragraph 107, there's reference to the submissions that I made in relation to there not being, 106 and 107, there not being findings all one way and not the other. Now, of course, that of itself doesn't get me home in relation to the fairness. But there were pretty important issues. One fundamentally important issue in our respectful submission, which was where the judge found in favour of the claimant at trial in relation to a very central issue in relation to the forging of a disputed email. It was an aspect of the case which was argued, if I may say, with force in relation to the possibility that he had indeed forged this disputed email. And there was evidence to support the contention that I argued before the judge. The consequences of a forgery finding before a High Court judge in a defamation trial will be readily apparent. And of course he didn't find. If he'd found that alone, I hope that would not be overstating it to say the case for the claimant would have been dead in the water in relation to that. But he didn't find that, and that's perhaps something, an example, a significant example in a respectful submission to show that he did not go on the wrong side of the line. In relation to fairness, the Court of Appeal, I'm going to go to Michel shortly, but they made observations in relation to paragraph 112 to the position whether about litigants in person. And of course I don't dispute anything in relation to the fairness, the insignificance of the position about litigants in person, but it is important in two regards to note, as the judge did, that this was not somebody who had fought the case throughout in relation to the case generally. He had had counsel instructed until very shortly before the trial, who I think was re-instructed in the Court of Appeal. I'm not sure of that, but there was certainly counsel instructed. There were solicitors on the record initially, and they came off the record at a short time before the trial. And you will have seen also from the judge's judgment that he makes observations in relation to a continuing role being played behind the scenes by that firm of solicitors. So, of course, we don't challenge the fact that he was representing himself in court. He was not all alone and at sea. And the other observation, which is really one that I've made already, is that the type of person he was must clearly be of relevance. In other words, taking a hypothetical example, if we are dealing with an unrepresented person who's somebody, for example, who's been the victim of sexual crime, that person requires a much more nuanced, sensitive approach than somebody you might think who is perfectly able to speak up for themselves, can, to use the expression, back to the judge, and somebody who has, on other findings, has been dishonest. I mean, there's no two ways around this. This is a forthright, dishonest man. We make that observation. So, of course, we accept about litigants in person, but we also say respectfully, one has to look at the parties that are before you, whether they're represented or otherwise. Paragraph 114. It's very strong language that the Court of Appeal has used. It leaves a little lack of clarity, and it's indeed a lack of clarity that my learned friends have not really addressed in our respectful submission in relation to whether this case is a case of actual bias or appearance of bias. Looks like, from the Court of Appeal, they are essentially arguing that the judge was actually biased, because the language is language described as threatening, overbearing, and frankly bullying. One is left with a regrettable impression of a judge who, if not partisan, they say if not partisan, but that's difficult to square with the following words, developed an animus towards the claimant. Now, an animus is obviously...
I wondered about whether the finding was apparent bias or actual bias, and you pointed out that in 114, the Court of Appeal talks about appears an impression, and on its own, that might have led to a conclusion of apparent bias. But I think 119 clinches it, Mr. Metzer. I think 119 is a finding of actual bias.
I agree.
Subject to what may be said.
I agree, my lord. I think that is right, and it's a little obtuse, but I think my lord's right. The 119 nails it, and it's more consistent with a description of somebody having an animus. An animus is a very strong expression to use about anyone, but that's what the finding was in relation to the High Court judge. And we make the point in our case, and we won't overmake it, but I don't want to sound unnecessarily overblown about it. But if a High Court judge has an animus towards a party, that is wholly inconsistent with his judicial oath. And it is inconsistent in any event, in our respectful submission, with what the judge actually found, because there are aspects in relation to the findings that are actually supportive of the claimant at trial. Not only, of course, in many of the areas in relation to issues of truth, which were, of course, heavily contested, but secondly, and perhaps significantly, he even says things like, he moves from obviously the first stages are the lengthy, I have to confess to that, my lengthy cross-examination of Mr. Serafin, but he moves after that by saying he warmed to him as the case developed and described his closing speech as a tour de force. That doesn't square easily with someone who has an animus towards a party, in my respectful submission.
Where's that reference?
The tour de force, my lord, I will find that for you. It's in the... I was going to go to the judge's judgment.
Come back when you're ready then.
Yeah, I will. I'm going to go to the judgment in a minute. Thank you. But I will find it for you. And finally, in relation to what the Court of Appeal said, we've got...
I mean, it's something like the aside, apparently, to yourself. He's either being obtuse or he's playing for time, and I can't decide which. Certainly gives the impression that the judge is aligning himself with counsel for one party against the unrepresented litigant in person.
I'm very conscious, and I don't want to abuse a position in relation to my status in the case. It is something I know the respondents have, not in the Court of Appeal.
No, quite contrary. It's very helpful to have somebody who was taking part in the trial.
Well, my lord, if I'm able to say this, it is never, ever in a party's interest for counsel to think a judge is overplaying their hand in support, just as it's no fun when one's on the other side of it. It would never have been in my client's interest to have engaged in any type of folie à deux with the judge, which is ultimately going to be to the disadvantage of my clients. And so if that's to be characterized as a sort of aside to counsel by a judge in terms of we're all lawyers here together, that would have been unhelpful and contrary to my client's own interests. And I say that, my lord, with the greatest of respect, because one aspect, of course, that we have dealt with in Schedule C relates to the Court of Appeal, if I can say rather... it's rather ironic, but at one point there's a reference to the fact that I was trying to ride back the judge. You've seen in Schedule C that we reject that as a proposition. Simply, I wanted to move on with the case. But it is never going to be in me or my client's interest to have a judge acting partisanly. And unfortunately, I've done this job long enough to know there are times when you just want the judge to row them, just to let me get on with my case. And I'm afraid to say my view of the case, it's obviously coloured by the fact where we are now, was that this was not a situation where the judge, yes, I accept there were times he was rude, I accept there were times when he was brusque, and I shall come on to the main authorities in support of this. There are times where he perhaps exhibited a level of impatience, which is not ideal for a judge, and I have to accept that. I don't act for the judge, but I, of course, recognise that there are concerns from the court. But this was not, in my respectful submission, a situation where the judge was essentially exhibited animus, was biased, actually or apparently biased in the way the case was presented throughout this trial.
So you're really drawing a distinction between matters which might aptly be the matter of a disciplinary complaint on the one hand, and matters which go to the fairness of a trial on the...
Yes, we do. We mentioned in our case there is, of course, a perfectly proper and highly important body of judicial complaints against judges. Of course, it's an very important body. Of course, we know, in this case, Mr. Serafin never went there. And I repeat my earlier observation, which is that there was a perfect opportunity for him to say, the judge did not give me a fair trial before the Court of Appeal. Absolutely nothing to support that contention. And finally, my lords, in relation to the Court of Appeal, before I go to the judge, to the judgment itself, relates to paragraph 117 of the 116 and 117. I think I've really dealt with that little bit in parentheses right at the end, where they say, we detect more than a note of concern in the fact that Mr. Metzequin's counsel felt that he had to make the last observation. It's difficult, again, for me I'm trying to avoid giving evidence, but I hope the court will understand, this court will understand, that is to be read as understood precisely for the concerns that my Lord Reid raised earlier, that one doesn't want to be in that territory of having too much help from a judge. It doesn't help. And when I say I wanted to give Mr. Serafin the opportunity because he's not represented, and despite my Lord being, if I may say, very fair in terms of ensuring that he understands everything very carefully, that was not meant sarcastically, nor was it meant as a warning. It was simply to reflect, as I saw it, how the case was being presented, and presented as far as Mr. Serafin's interests were concerned. And then at 117, the judge's conduct is all the more surprising and troubling, given that the claimant was acting as a litigant in person, and English is not his first language, albeit he spoke it well. I think I've said enough about that. His English was good. He was the type of litigant who was well able to deal with the thrust and the flow and thrust of the court process. I am very conscious of the time, but can I just, by doing that, just
very quickly, I know you're almost running out of time. Disclosure. A lot of criticisms by the judge of the claimant. Where is this document? Where's that document?
Yes.
I'll give you a nanosecond to produce it, all that sort of stuff. In circumstances where you had not applied to the court for further disclosure beyond what you already had. What do you say about that?
What I say about that, there is a case that I do want to spend 5 minutes on, if I may, which deals with what a judge should do when a party is in a chaotic position in relation to the status of their case. So I think that is partly explicable in terms of the judge was actually presented with a real difficulty in terms of the way that Mr. Serafin was actually presenting his case. And I don't mean this critically to him in this regard, he's a litigant in person, but there was a frustration about it, but it wasn't really about issues of disclosure per se. It was a recognition that Mr. Serafin's case was not, was in a chaotic state, and I shall take that briefly to an authority that supports that
Very
proposition.
well, thank you.
Sorry. Just give me 1 moment, please, my Lord. I'm really short of time. I think just to deal shortly with my Lord's point, and I want to do it shortly, I think we've dealt with our hope at paragraph 60 of our case. That's at EB 75 on the disclosure issue. I'm going to go, I hope I'm not trespassing too much. I think the law is important for 5 or 10 minutes, so I'm hoping I'll be given that indulgence. Can I just tell my lords and my lady, because there are important areas, credibility findings of the claimant by the judge are important in this case, and of course my Lady Arden's request we shall comply with in relation to giving a full list in relation to that. But can I say that the section that deals with that in relation to the credibility findings, you can find, it's in the judgment, and they start at paragraphs 86 through to, that's EB 332, through to EB 341. Those are credibility findings in relation to the claimant. They are lengthy. They are, if I can use a different word, devastating against the claimant. This is a libel trial, after all. This is somebody whose reputation is at the forefront. Can I, just for listing purposes, give the paragraph numbers? 89, 90, 91 to 2, 97 to 100, 101, 103 to 108, and 109 through to 128, and finally 130. I would respectfully ask this court, please, to look at those findings, credibility findings against the claimant. I've noted the point about the forgery allegation. That's dealt with at paragraphs 145 to 151. It ends up finding in the claimant's favour at paragraph 150. Please note the other credibility findings. Ms. Zanika, that's paragraph 151. She's an important witness in support of the respondents now, the appellants now, the defendants at trial, as is Elizabeth Howard, the 2 women that he conned out of huge amounts of money by sleeping with them at the same time. Paragraph 161. By contrast, 2 important credibility findings against the claimant at trial, which are important. Ms. Parillac, paragraph 169, and Piotr Serafin at paragraph 178. The other witnesses, taking my Lord Reed's point, the other witnesses are dealt with at paragraph 179. The judge operates a broad brush approach in relation to them, saying that he didn't really believe on either side in relation to a number of the witnesses, including the one that was mentioned. So given my tightness of time, I'm going to say nothing more about the evidence directly, unless I'm asked. But can I just take you briefly to the authorities? I'm going to do this very shortly. There's really two cases that are the most important, but I better just mention, at least in passing, chronologically, the 6 cases. The first one in the authorities bundle is tab 24, which is the case of Jones and the National Coal Board, which is, of course, the famous decision of Lord Justice Denning, as he then was. So that's EB 1293. The head note, factually very different from the present cases at 1293. It's an ironic case given the present allegations against the judge, because Lord Justice Denning is absolutely at pains to indicate that the judge had anything other than the best of possible motives in relation to the mistakes that Lord Justice Denning found that he made, but it was not actuated by ill motives. You can see that in the holding at page 56. Significant, of course, it's a very old case, and that is important because it's a civil case, but it's back in 1957, and the position has obviously changed very far in relation to the law now. Can I, just taking it very briefly, just please ask the court to note the basis of the appeal at pages 61 to 62, and at page 63, sorry, at the bottom, EB 1301. This is really where we get the reference to the descent into the arena, which comes from a case called Ewell v. Ewell. You'll see at the bottom of page EB 301. He, so to speak, descends into the arena and is liable to have his vision clouded by the dust of conflict. That's how where the graphic expression comes from the case of Ewell and Ewell. Of course, we recognise, and we've sought to do this in our case, the judge should not descend into the arena. As soon as to use that type of language, it's gladiatorial combat, it's acting as a second advocate, it's no longer performing the right role as the arbiter of the truth. And so there's no difficulties with accepting these as general principles. We note it's a very old case, and remember now, as the last 2 cases I do need to take you to briefly, we have to look at civil law and the management of civil trials very much with a different lens from 1957 in our respectful submission. Can I just briefly take you to Michel and the Queen, because that is the case that is referred to by the Court of Appeal. That's at tab 32. Criminal case, and of course, whilst accepting the general propositions that are set out in relation to fairness in criminal trials and civil trials, there is nonetheless a fundamental difference, which is almost trite to say it, but I shall say it nonetheless. The significance in a criminal trial is that one cannot have a judge, whether it's a jury or in this case jurats, being influenced improperly and inappropriately by a biased judge, because that it goes way beyond the judge's function in terms of influence in relation to a different body that's making the actual credibility findings and finding the decision on the evidence and the law. Of course, the principles apply equally, but there is a fundamental difference in our respectful submission in relation to a judge who is trying a case, having to make their own credibility findings on the evidence ultimately. There's nothing wrong, we say in principle, with a judge indicating areas of concern, even trenchantly and forcefully, provided he or she keeps an open mind before reaching their ultimate decision. So again, no issue with the principles set out in Michel and the Queen.
You have a page number?
Yes, of course. The case was EB 1395.
Sure.
That is an extraordinary case where the Commissioner, you can see the facts, intervened with substantial questions on 273 occasions, 138 of them during evidence in chief, taking up over 18% of the defendant's time in the witness box. You can see the language descended to described as variously sarcastic, mocking, and patronising, and you can see that repeated at EB 1399 at B to C. I'm not going to spend any longer in relation to Michel. There is no criticism. Of course, that's a decision which we accept, and the full principles are set out in relation to EB 1403, paragraph 31 at H, through to paragraph 33 at 1404. There is, in parentheses, we do say this. Paragraph 32 at 1404, the need for the judge to steer clear of advocacy is more acute still in criminal cases, really making the point that I've made, particularly important in a criminal case where the judge is not the ultimate arbiter of finding one way or the other in an adversarial process. And at 33, none of this is to say that judges presiding over criminal trials by jury cannot attempt to assist the jury to arrive at the truth. On the contrary, they should. That's part of their tasks. Judges exist to see that justice is done.
They do make clear in 31, at the foot of page 1403, the last sentence, that the core principle that they're applying applies no less to civil litigation.
Yes, I've really made that clear. I did refer the courts to 31. Of course we accept the judge cannot descend into the arena. The judge remains aloof, neutral, but that is not the same in our respectful submission with asking questions, understanding the evidence, clarifying points, and at times indicating concerns about the way a case is presented, and I shall take that briefly with my last case. And at times, and I've said this already, but I'll say it one more time, not perhaps being on best behaviour mode. That is, but we are not here, in my respectful submission, to look at whether, of course, the irony of this situation about this High Court judge who received what has to be said as a pretty devastating attack in the Court of Appeal. Of course, he's not here to say anything. He has no comment to make on it. We don't act for him. But one I'm sure will readily recognise it was quite an extraordinary attack upon him. The case of Kofu-Adu, I'm not going to spend more. I'm going to ask the court, though, to look at. That's at tab 40, which is at EB 1557. This, if I may say, this was, I'm going to use an expression which I know the court will forgive me. He's a bit of a repeat offender, this late judge, I'm afraid, because there's even mention in the context of this case, of another case. This judge, in that case, a criminal judge, a civil judge and a criminal judge, he is severely criticised.
Which case is this?
It's a case called London Borough of Southwark and Kofi-Adu, EB 1557 through to 1578.
Thank you.
Given the shortness of time, I'm just going to ask, there's an important point I make at paragraph 18 of that judgment, EB 1559. The trial was estimated to last 1.5 days. It extended over a further 2 court days, and a bit further down on 18, it is a regrettable fact that the judge's conduct of the trial was the main reason why it all took as long as it did. The transcript reveals a constant stream of interruptions by the judge throughout the trial, including sometimes lengthy passages of interrogation of the witnesses, both during examination chief and during cross-examination. One of the things that at least my learned friends have acquitted our judge of was that he kept to the time limit. The case was listed for a certain period. It finished within the time. This is a judge doubling the length of a case and more. And there's something to be commended to a judge who controls a case and ensures that the time limits are properly met. And I'm just going to put for your references the huge amounts of criticisms in relation to this judge are, can I give you the paragraph numbers, please? Paragraphs 53, 55, 58, 63, 66, 74. The reason I can say with some, I hope, greatest respect to him, to say he's a repeat offender, there's a reference to paragraph 122 to another case, a case called Shine, where the same judge is criticised. That's at paragraph 129 of the other case. And finally, can I say this, ask for these observations to be general observations which the court gave, which are of some assistance. The Court of Appeal said, at 141, which is at page 1576. Paragraph 141, halfway through, it is, after all, trite. Issues as to credibility are preeminently for the judge at first instance and not for this court. That's really a point that Mr. Price has already advanced, but it is something of significance that here we have credibility findings are for the judge at first instance and not for the Court of Appeal. And then the judge's conduct at the trial, they say this before heavily criticising the judge, and with greatest respect one can readily see why. It is important to stress at the outset that within the bounds set by the Civil Procedures Rule, a first instance judge is entitled to, these words, a wide degree of latitude in the way he conducts proceedings in his court. Then 144 deals with yield and yield, which I've really taken you to. 145 really is, this is the first case that we find in relation to the change of approach in civil cases from the Lord Justice Denning's days in the Jones case. Nowadays, of course, first instance judges rightly tend to be very much more proactive and interventionist than their predecessors. So a recognition of the importance of judicial control of cases. Then we have the decision at 147. And finally, at 151, really the point Mr. Price has made, a retrial is always a last resort. And you've heard the draconian effect of an unfair trial being in relation to a retrial. I'm not going to deal with, there's one other case which I'm not going to deal with, a case called Sarabet Singh, but the two cases I just want to finish with, briefly with RG, which I shall go to, and then finally with which I respectfully submit the most recent case, and actually the most important case in my respectful submission in relation to this court's considerations. It's a first instance case of MMP Enterprises.
Well, why don't you just give us a note of the tab numbers? And I'm afraid you're so far out of time that even eating into your reply time, you're not going to have enough time to take us to these. So if you just give us a reference.
Of course I will. For Re-G, that's at the reference to that, it's at tab 35. So that starts at EB 1425.
Yep.
And the bits that I would respectfully ask the court to look at in particular, it's a decision of Lady Justice Black, as she then was, and it's particularly paragraphs 31 at EB 1435, 34 through to 38. She talks about different judges have different styles. Yep. She talks at 38 about the fairness of hearing cannot be assessed mathematically or scientifically and so on.
Yep.
So that's that case. Paragraph 53 as well in relation to the difficulties of a judge not having a right to say how their own conduct is being assessed. Sarabet Singh, there are passages, can I just mention that's at tab 37, but that's of much less assistance just in relation to the issues that you will need to consider. Yep. But it's the head note, that's at EB 1517, and then it's paragraphs 30 through to 36, really incomplete, the complete section. That's EB 1520 to 21. I hope I'll be forgiven. The last case, M&P Enterprises, may I just have literally 5 minutes, because I think this is going to help the court a lot in relation to the concerns.
Where about is it?
If I'm not, then I'll just give the references.
Yep. Where is it?
It's at tab 16. It's actually the authority that my learned friends have introduced in their case, and we're very grateful to them because we think it's a great assistance in relation to what the court needs to decide in relation to which side of the line this judge conducted himself. So that EB 1071 to 1131. I'll be very quick. That, of course, is a decision as a first instance High Court judge. He relies, Mr. Justice Hildyard, relies heavily upon the Re-G decision of Lady Justice Black.
Yep.
I'm just going to give the references, but these passages really deal with, I hope, very fully in relation to a whole series of criticisms about how the judge conducted the case.
Yes.
Uses language highly critical of the judge, but in every single instance, individually and cumulatively, found that the judge did not act unfairly. And so paragraph 1 is really the point that my Lord Wilson said in relation to whether it's a bias or an actual bias or an appearance bias. Paragraph 2 deals with the parameters of the fine line between robust case management and disruptive judicial intervention. There's a summary of the law in relation to other cases that I've given you between paragraphs 17 through to 24. And then this part is really the point I would ask the court to look very carefully at, please. It's paragraph 29, paragraphs 35 to 39, looking at the wide-ranging criticisms of that particular judge, and they are very wide-ranging, much wider than, if I may say, than the present case. So that's 35 to 39. Paragraph 43, in relation to, this is the point about the chaotic state, which I hope deals with, to some extent, concerns on issues of disclosure, arguably, and general conduct of the way a case is litigated. Paragraphs 72 at EB 1090, 74, hearing cried out for firm management, and that's EB 1091.
Sorry, after 72...
74, please,
74,
my Lord, that's EB 1091.
Yeah.
76, 1 and 2 on the same page. Paragraph, and then the conduct of the trial, which is starts at paragraph 81 at EB 1093, and then these important findings in relation to what Mr. Justice Hildyard found. These are the ones I most rely upon. And I'm afraid there are, I think, 12 references. I'm just going to do them slowly, I hope. 93, 94, 97, 101, 102, talking about crotchety and grumpy behaviour, 105, 106, 143, described the judge as unnecessarily acerbic, 147, numerous interventions by the judge. In this case, on any view, there were interventions, but they were not frequent over long, lengthy passages, which is one of the criticisms in this case. 159, 164, the appellant in that case was somebody not entitled to be treated with kid gloves. I echo that observation in relation to Mr. Serafin. 173 to 175, issues about judge being stern and sharp criticism of his evidence, which is again not regarded as unfair. 177 to 179, dealing with judges showing, hardly unknown for judges to betray their views and even scepticism, but not unfair. Judges entitled to form, as long as they don't form a final view, they can have an indication at early stages. And so it's 175 to 179. Then 183. And finally, 191, and then towards the end, 207. Impartiality does not require the judge to forsake the formation and sometimes gradual hardening of a provisional view until after closing submissions. That's 207. And then 210, conduct of the judge, some of his conduct towards counsel was abrupt and regrettable on the basis of the transcript alone. That's 210. Then 212, judge was excessively interventionist, disparaging, and did unsettle counsel. Described it as unnecessary and discourteous, but it was not unfair. 212 through to 214, the judge was difficult, unsympathetic, even disparaging at times, and counsel was not interventions and criticisms of counsel were not the real reason preventing the appellant's cross-examination developing momentum and cogency. And then in the concluding findings, 229 to 230 and 231, right to the end, to 232, which ends by concluding judgment and saying that the whole trial was fair. The judge, there's heavy criticism of the judge, but it did not cross the line into unfairness or the appearance of bias. So I know I've gone over my time and I'm very grateful, but I think with the greatest respect, although it's a first instance judgment of the High Court, it's of hopefully existence to this court.
Thank you, Mr. Metzer. Ms. Page, you can finally rise to your feet now.
Well, I am the one to blame for the fact that we started late because...
There's no need to apologise. We understand that there was a misunderstanding.
I give evidence as to what I saw
Yes.
on the court list last night. I'm going to start, if I may, with unfair trial, because I think it's very important to drill down into what happened at the trial, because it percolates into the findings of the judge. It percolates into his finding on imputation 13.4, and it percolates into his findings on the Section 4 defence being proved. And this morning, Mr. Price was criticising the failures of the defendants in their journalism that were cited in the Court of Appeal judgment had not been put at trial. Now, in fact, they had all been put at trial in the attempts to cross-examine the defendants. Why they didn't contact the bookkeeper, the treasurer at POSC before drawing a conclusion that there had been theft of the cash takings, why they didn't approach the management of Colby House, why they didn't approach Mrs. Howard to find out whether it was true that she had not been paid back. Why, and this goes beyond what the Court of Appeal referred to, why there wasn't approach Mr. Legeza, who is another investor who is in the process of being paid back. And I want to show you some of the instances where the cross-examination is stymied in one way or another. But before I get to those parts of it, I want to just make a few observations of a general nature. First of all, it's said that the point is made there was no evidence from the claimant. Well, that would have been highly subjective and of little value. I mean, it's of no value to the court if every time a dissatisfied litigant thinks he's had an unfair trial, that the court's going to have a witness statement on that and attach any weight to it at all.
But couldn't he say, I was put off by this, I was going to ask a whole series of questions, here are my notes. Why can't he put in evidence like that? Because that would show with concrete evidence that something had gone wrong which had a material effect on the proceedings.
Well, one can see it from the transcript, I submit.
Right. That's what we want to see.
And that the court should be looking at it objectively and critically. And in any event, it's not fair to the trial judge for a Court of Appeal to say, well, he had a whole list of questions he was going to ask, and he was stopped from asking them because the judge's manner put him off.
Ms. Page, I wondered whether you were going to refer us to the grounds of appeal to the Court of Appeal at 498, if that's convenient for you.
Yes, the grounds of appeal.
Paragraph 5.
Ground 5 puts it into 5 elements.
I was looking in particular at the second sentence.
Making gratuitous interjections? Oh, sorry, I've listed them out.
Yes,
Separately.
putting C under enormous pressure, making it extremely difficult for him to conduct the litigation.
Precisely.
Yes.
There is, so one's got to look at it objectively, and I'm going to ask you to look at it objectively on the fuller transcript that we've got. there's a criticism about him being a difficult litigant because he was always trying to make speeches. When you look at the whole of the evidence we've got, it isn't the totality because we don't have the last day's evidence. But apart, he is accused of starting to make a speech by the judge, sometimes after he's only said 3 words when he's trying to cross-examine a witness. We all know that trials with litigants unrepresented are difficult. They're difficult for judges, they are difficult for opposing counsel, and as the Equal Treatment Bench Book reminds judges, unrepresented litigants are operating in an alien environment in what is for the litigant effectively a foreign language. And the judge is supposed to be umpiring to create a level playing field. And if that means a bit of levelling up, as between the litigant and the highly experienced trial counsel, that is not favouring one side over the other. That is creating a level playing field. Now, I want to start with the allegation of a forged email to which my learned friend attaches great significance. I think his expression was that if it had been made good and the judge didn't uphold it, the claimant's case would have been dead in the water. Now, that was an allegation that the claimant had manipulated a document which he produced in his disclosure by forging additional words that it was said the sender had not put into the email when it was sent. So it was an attempt to pervert the course of justice. The judge concluded it was a very serious allegation, but his conclusion is at 150 of his judgment. It's Core Volume 1, 344.
Sorry, did you say 144 or 134?
344.
344, thank you.
He starts it on the preceding page. It goes on for numerous paragraphs, but the conclusion is ultimately, I've concluded, I cannot be satisfied that he did. On this issue, the burden of proof rests on the defendants. The message remains mystery. Accordingly, I've decided I shouldn't hold it against the claimant. Now, we need to go, if we may, to the Respondent's bundle, which is the transcript, to see how this emerged. It starts in our bundle, page 182 of the print, 2296 of the electronic.
In fact, it doesn't seem to be the electronic, but there's an RB number which helps enormously on each of your pages. There are 3 paginations, there are actually 4, but 3 in the right-hand side, and the one that seems to work and to correspond with the pagination on the computer is the RB pagination.
Oh, good. Well, then that will help. I only need to refer to one numbering. So it's 182 for everybody.
Thank you.
So this is the very end of the cross-examination of the claimant. He's been in the witness box for the best part of 2 days. It's introduced by my learned friend at B. Now, this is the last point I wanted to ask you about. And he says, I've got a copy for my lord, and he hands up this document, which, as he says, I need to introduce at this stage. This is for my lord, and this is for the witness, and he explains this is something that's arisen ex improviso. And he explains at C that it's an email purportedly from Ms. Woznisha, and then he asks the witness to go to the original. Now, if we go over, there's quite a lot of toing and froing in this about what page we are on, and there's a lot of confusion apparent on the part of the claimant, albeit possibly clearly being interpreted as more obstruction by the judge. And if we go to the top of page 183, Mr. Metzer, could you look please at the second document? The judge, is this the one you've handed up? So this is to contrast with the one in the disclosure. My lord will see the first document is the same. And the judge says, so it is an exact duplicate, is it? Mr. Metzer, no. The judge, oh, I see. Mr. Metzer, it'll become very clear very soon. Then what might be thought to the impartial observer to be a slightly cosy exchange, the judge says, well, I thought you were warming up to something. And counsel replies, I hope that the last point, the last point in his cross-examination, will be of interest to the court. And then he says, do you see a document that looks very similar on superficial looking? So it's then put to him by Mr. Metzer, as we see in the big question next to E, that the email disclosed I should say, a large lever arch file of disclosure of the claimant in January 2017, that he is saying, I have the sender's original and there is a difference. And then at G, Mr. Metzer saying, this is the real email that came from Ms. Wozniacka to you on 22nd of December, and you have manipulated the email. And he says, no, I've never manipulated anything. Now, just to pause there, the neutral umpire in an adversarial system should be stopping Mr. Metzer at this point, because if the claimant had been legally represented, his counsel, if competent, would have got up at this point and said there was no challenge to the authenticity of the document disclosed by my client. So one would expect the neutral umpire of the judge to say, just pause a moment before we go any further. Have your client served a notice to prove under CPR 32.19? And the answer would be no. When the judge might say, because we've got the litigant, not counsel on the other side, when was the last date by which your clients could serve such a notice under the rules? The answer to that is the latest date for exchange of witness statements, and that was 2nd of June 2017. The document was actually disclosed on the 24th of June 2017, and we are now in this cross-examination on 31st of October 2017. The judge would then, the neutral umpire would say, are you making an application to extend time for service of a notice to prove? If so, do you have a witness statement in support, because it is mandatory, if it's out of time, and does it address the Denton principles? The judge would then have allowed the claimant time to consider the position. He would have been able to check back on his emails, look at the electronic version, think about it, make representations, and the application may or may not have been allowed. So that is what a claimant's counsel, doing their job properly, would have assisted on, because CPR 3219 prevents an ambush of this kind. So if we go back to the transcript to see what in fact happened, the cross-examination continues over the page. There are continuous exchanges between counsel, the claimant, and the judge. The claimant are clearly seeming, at any rate, to not understand and to be bewildered, and we can skip over those exchanges and go to page 187. And Mr. Serafin is continuing to appearing to be not in the right place. I should say that Mr. Serafin had different bundles to the defendant and to the judge. He had been required at the PTR to provide the trial bundles. He did provide a set of trial bundles to the defendants. The defendants didn't like them, I think, whether it's to do with pagination. So they prepared their own, and they provided them to the judge, and they offered them, as I understand it, to the claimant in return for £120, and he refused. So he's operating from the wrong bundles. At the top of page 187, the judge says he is, this is the passage where he says he's either being obtuse or he's playing for time, and I cannot decide which. Ms. Serafin says, I'm sorry, but I'm somehow confused. And Mr. Justice Jay says, or he is getting flustered. So pressure from the judge. There's then pressure from counsel on the litigant between C and D. Counsel said, are you doing this deliberately? I'm not doing anything deliberately. I'm trying to find out you gave the document, and so on. This carries on. One can continue then to page 189, where the judge, this passage starting between F and G, going down to H, is referred to by the Court of Appeal in their judgment. Paragraph 116 is one of the passages they added to what was in the schedule provided by Ms. Marzek. You are understanding, so he's explaining the point to the claimant, and at the bottom one sees that is what's being put. You deliberately put words in her mouth. And over the page, 3 words come out of Mr. Serafin. The judge says, and therefore have lied. Well, did you or did you not? Another 3 words comes out of Mr. Serafin, and the judge says, well, how can you explain what is in the bundle? So this is the judge speaking, which does not seem to be the version which was sent. And counsel said, yes, I just wanted to give Mr. Serafin this opportunity because he's not represented. And this is the passage where he says, despite my lord being very fair. And then at D, counsel's cross-examination, just under D, and you on oath have said that you've not changed the document. You realise you could be liable for perjury. Mr. Serafin says, yes, I realised that, but I never changed any document. This is an email between her and me, and I'm not quite sure I've still got it. I had special file for those documents. And the judge says, well, I think this is so important that we should make available the electronic copy, because you understand what the consequences are. If I think you are lying, I will send the papers to the Director of Public Prosecutions, and if you are found guilty by a jury of perjury, you will go to prison. Do you understand? Yes, I do. And then the judge adds, has the penny dropped? You understand. Now that is in a circumstance where that exchange ought never to have taken place if the proper procedure had been followed in terms of CPR 3219. And it's very difficult for judges dealing with litigants, but they do, if they are going to case manage, they have to case manage both sides fairly and equally. And there was a great deal of case management of the claimant. The moment he shifted his case, and I want to show this, the moment he shifted his case in cross-examination, the judge said, I'm not allowing you to amend your case. Something he put to a witness, which we'll see, the judge then demanded to know where in his pleadings this was. When in re-examination he started to ask a leading question, the judge jumped on him saying there'll be no leading questions, but as we'll see, the defendants were allowed to shift their case on truth. They were allowed to ask leading questions, and there was no, the one attempt that was made in these transcripts by the claimant to say that there should be more disclosure from the defendants, the judge simply brushed off.
Ms. Page, did it emerge at the trial how long the defendants had had the document that was produced like a rabbit from a hat?
The lists of documents were exchanged on the 24th of January. So we were, I think, on the 31st of October on this date. Witness statements were exchanged on the 2nd of June, at which point the claimant was unrepresented. Perhaps I can just give you the dates of representation. I think it might help. So disclosure, lists exchanged 24th of January 2017. On the 14th of March 2017, Miss Marzek and her instructing solicitors ceased to act. 2nd of June, witness statements were exchanged, and the claimant was acting in person. His witness statements arrived with the then solicitors for the defendants a few hours late, I think at latest about 6 hours late, and an application had to be made for relief of sanctions. On the 14th, and I'll come back to that, on the 14th of June, my instructing solicitor came on the record for the claimant, and he acted until 28th of September. Apart from the application for relief from sanctions of being 6 hours out of time on his witness statements, for which he was made to pay £8,000 in costs at the hearing, he was represented by Mr. William Bennett of counsel, and that was the only counsel involvement, because no counsel would do the trial on a CFA. So Simon Byrne came off the record on the 28th of September 2017, and the trial started on the 30th of October. In the meantime...
Sorry, the solicitors came off the record when?
Sorry?
I beg your pardon, the solicitors came off the record when?
Solicitors came off the record on the 28th of September. There was...
Ms. Page, I think my question was, did it emerge at the trial how long the defendants had had the document that was produced like a rabbit from a hat?
Oh, sorry.
I meant to ask that question.
Yes. It was said that it was overnight.
That they got it that night.
Overnight, yes. So I'm so sorry. You'll see it at the bottom of page 190.
Thank you.
I think was obtained overnight. Just to complete this, what happened here, what the counsel thinks at the top of 191 he's now completed his cross-examination, and that he's going to show an electronic, and in fact then happens that a mobile telephone, as so far as one can gather, is handed up to the witness to be shown the document that emerged overnight on the phone, and that there's a series of exchanges about that, and then while this is going on at 193.
So when the interchange with the witness was going on, the witness hadn't got the two documents in front of him.
Didn't quite hear that.
Well,
yes.
At what stage did everybody in the court have a copy of the two documents in front of them?
As I understand it, from the beginning of the that section of the cross-examination. So from where I started, which
yes.
was at page 182.
Thank you.
Then, if we go to D, to conclude this allegation, Mr. Serafin said, this is what you gave to me. This is the document which actually you gave to me now, and one paragraph is completely omitted here. There's nothing. The judge says, what are you referring to? And then the judge says, you see, what you're doing is you're not answering my question, and what you are doing is trying to obfuscate, and I'm going to sit here until I pin you down on this. Which paragraph do you say is missing? Just read it out before I lose my temper. And then 2 pages on, one at page 196, it's made entirely clear by counsel between B and C, where he says we did check this because this is an allegation of fraud. And then before we leave this part of the transcript, if we can go to page 201.
Well, before we leave 195, actually, there's a remark that struck me anyway, between F and G, when he's being asked, effectively, the discussion of whether the difference between the documents is a result of an error in printing, and the judge is asking for, effectively, for that to be established. And between F and G says, well, I'm sure you can find all sorts of reasons for not being able to do it.
Quite right, I should have referred to that. And he's told to come to court with the electronic version, and at H, the judge says, you'd better come along with that tomorrow morning, because I understand your point, it could just be a printing error by you, but if it is, you will have to demonstrate it.
Yes, so the onus is on him to rebut the allegation.
And then just before we leave this section of transcript, at 2:01, one sees here that at the end, his cross-examination having concluded and all these things have been put to him, all the allegations of truth, and Mr. Serafin says, one sees just before D, he says, as regards the POSC and the cashier, their lies and fabrications, I've got a picture of it, meaning the cash register. I'll explain that in a moment. I've got statements from two people I can refute very quickly. That's first one. Then he said the second one, I was accused that my ex-wife was working there. I'm going to take you to the Mrs. Serafin point. I will ask for any documents the defence will produce to show that she was there employed for work on any invoice. This is something where the judge makes a finding of truth against him. What she presented or anything else was everything is just hearsay gossip. And the judge says on him sort of trying to articulate a request for documents, these are really just submissions. You can make submissions at the end of the case. And then he says it's not really evidence which is going to help. And he says, Mr. Serafin says they can't produce any evidence because there's none. And the judge says you can tell me that at the end of the case. And then Serafin says with the cash register, if you allow me to present those pictures that are very clear and they are dated. Now, at the beginning of the trial, the judge had to deal with an application by Mr. Serafin to put in a short, late witness statement from somebody who had come up with 3 photographs of the bar area in 2008 and 2009, showing the cash register and showing the till roll. And he was refused permission simply to put those 3 photographs in with this short witness statement. He comes back to it again here, and the judge says between F and G, well, I've refused you that because you should have produced those before. And yet he can have a document sprung on him overnight with no challenge to authenticity, but he's not even allowed to put 3 photographs in evidence, which refutes the case of the defendants that there was no cash register.
Could you just explain very briefly why it was produced overnight? Was there some disclosure that I'd missed? And
I don't know. What I infer, Mr. Metz will have to explain this, is that the witness, the person to whom the email disclosed by Mr. Serafin had been sent was in court because she was going to be a witness, and she seems to have come up with saying that my document is different. But the judge goes into this in considerable detail in his judgment and then concludes that it's not been proved that it was an allegation of fraud. It shouldn't even be on the face of the judgment if proper case management is going on. Now, then I want to turn now to criticisms of the claimant of his disclosure. And failure to call witnesses. And I want to go first of all on this question of how disclosure was handled by the judge to a Colby House matter. And if we go first of all, if we can keep open the respondent's bundle, but we need to just have a look at the amended defence. which is at page CV2, core volume 2, page 449. It's the amended defence, paragraph 14.48. And we can start or at halfway through the particular of truth. At a few lines down in the amended section on page 449, in order to profit from his new position, this is Colby House, the claimant who is not employed under a contract but paid for each separate piece of work he did persuaded the manager and the governing committee to allow him to carry out expensive renovations which were not necessary and which he knew would be paid out of charitable funds and which would not have to be done had he not persuaded them they were not necessary to do. The misconduct was, and then they are listed quite specifically, bathroom equipment that was in good state removed, paint work on the entrance door, decorating the dining room, rewiring work, refurbishing the manager's office. Now, at common law, there was a long-established rule known as the pleading with particularity of indictment rule, that your particulars of justification should be pleaded with the particularity of an indictment. That was confirmed since the Defamation Act 2013. First of all, it was confirmed recently before the Act by the Court of Appeal in 2012 in the case of Ashcroft and Foley, and it was applied by Mr. Justice Nicklin to a Section 2 case, Morgan and Associated. We don't have these in the authority bundles, and I don't think it'll be controversial. But the Court of Appeal explains in Lord Ashcroft and Foley that the reason for the rule and its comparison with the criminal indictment is that the particularity is intended to inform the judge and counsel, the judge and the claimant, exactly what the case is against the claimant, and to stop the other side, as would be the case with a criminal prosecutor, from shifting his case without the permission of the court and without making an amendment. And 1448, it complies with the rule of a particularity of indictment. That the reply has to respond to that, disclosure responds to that, the witness evidence responds to that. Now, the claimant called 3 witnesses to refute the Colby House allegations. They were the chairman of the trustees, another trustee, and the manager. And in defamation case where there's a truth plea, although the burden of proof is on the defendants, the claimant goes first. And now one of them, these witnesses, Miss Romish, I'll never be able to pronounce it, Miss Romishowska, Miss Marzek's the expert, who was the chair of the trustees, we go to her evidence. Her cross-examination starts at page 254 of the Respondent's bundle, but we can skip over almost all of it. Because go to 271, and we can skip over it because the paragraph of the defence of truth that I have just invited you to look at was not put to her at all, nor was it put to the other 2 witnesses from Colby House. And there was no witness statement served by the defendants purporting to prove that part of the defence stroke indictment. So if we go to page 271, this is, so well into her cross-examination, at C, counsel puts the question to her how much does he earn now? In other words, how much as the handyman, maintenance man at Colby House does he earn now? And she says, that I'm sorry, I could get that information to you. I didn't come prepared for that. And no reason why she should, because there's no issue on it in the pleadings. Well, we would like to know that. Counsel explains just before E, we learned that he's now working again at Colby House. Again, no issue on the pleadings relating to this. He's working there again. Counsel at F, so this is new information for us. So that information can be obtained. Yes, she says, certainly, it's something I have to go away and arrange for the court to have. The judge then says, yes, you can get it to us. I'm just thinking of the mechanics. She says, yes, the bookkeeper. I'd say, my lord, which is tomorrow, isn't it? Yes. I could ask her to dig it out. And then it's further clarified over the page that the judge, she says, she seeks clarification at the top, any ongoing estimates. The judge says, and invoices. So the judge joins in on this sort of open season on disclosure, for non-party disclosure. The judge says, how many are there likely to be? And she says, well, it'll be water and plumbing. And counsel says, all right, if you can get that information, certainly. Then at the end, the conclusion of her cross-examination, they come back to the subject, and that is at 280 of that bundle, after examination, the judge between F and G says, thank you very much for your evidence, and the witness says, how can I get this information? And the judge says, what the most convenient way would be, do you know any witnesses who will be giving evidence later? She says, do you want to see invoices of work done since we re-employed? The judge says, that's right, since we reused Mr. Serafin. And the contract, says counsel. She says, no contract. And then the judge at B, on the next page, says, no, all the relevant documentation. I suspect it's very few documents. Do you have an email facility to scan it? And he then says, the lady in front of me, so the associate will provide you with an email, and you can send the information to her. It will come through to the court. Once it comes to the court, everyone gets to see it. Counsel then says, my lord, can I ask this? The invoices of not just since he came back to work, but the invoices of all work he has done. I tell you why, because we've had disclosure from the claimant of the invoices he's chosen to disclose. It's not necessarily accepted that those are the only invoices that relate to work he's done. And the judge says, yes. Now, it's as if the claimant is simply not there. Now, the judge, as a neutral umpire, case managing a complicated and heavy libel action, would, the moment the information was asked for, several pages back, would have said, Mr. Metzer, has there been an application by your clients for a non-party disclosure order? And the answer would be no. Are you making such an application? The answer presumably would be yes. And the judge says, well, I will hear your application, but you'll have to take me through the criteria in CPR 3117 and explain how the criteria are met. And as we see, that didn't happen. At least it doesn't appear to have happened. The claimant is present and simply ignored. And then if we go to the judgment at CV, Core Volume 1, 322, see what happens in the judgment. So it's paragraphs 34 and 35 of the judgment. The judge says, the extent and propriety of the renovation works is in issue. So this is Colby House. The claimant has disclosed invoices covering the period 2013-2015. At my request, the chair of the Management Committee at Colby House has provided copies of all the claimant's invoices in her possession. This further documentation reveals significant gaps in the claimant's disclosure for 2013, as well as further work done in 2016 and 2017. The Colby House total is 65,000, to which will be added a further 1,600 to reflect 2 invoices the claimants had disclosed but not in their possession. At this stage, I'm not implying there isn't anything necessarily suspicious about the claimant's failure to disclose all relevant invoices. The omission could be attributed to chaos rather than deception. And at 6, if we go, while we're on the judgment, at Core Volume 1316, the judge had said, at the last sentence of paragraph 6, much has turned on my assessment of the oral inference, and the inference is to be drawn from some of that evidence as well as from the absence of documentation and relevant witnesses. There are a number of references in the transcript to the judge saying, you haven't disclosed documents, I will draw inferences. So there was no application under CPR 31.12. Such an application would have ensured that the non-party disclosure sought was clearly specified. It had to be relevant to the statements of case, and that had to be demonstrated on the application. And of course, proportionality had to be considered. And the claimant would have been given a proper opportunity to respond. And I should add, I didn't make clear, that the disclosure order pursuant to which the claimant gave disclosure of his own was a direction for standard disclosure. So that was another example of case managing to the advantage of the defendants and to the disadvantage of the claimant. It's simply unacceptable. Generally on disclosure, if we go to...
Well, can I just pause a minute?
Yes.
This particular bit of case management was something that was on the way to Mr. Serafin actually having a finding in his favour on this point, isn't it? In the sense that the Colby House allegations were not found to have been proved.
That is correct, but there was no witness was being called to say that he had replaced unnecessary bathroom equipment. This was a massive fishing expedition. It can't have been anything else, because no witness was going to come and prove the indictment in paragraph 14, I think it was 38. So let's get some documents off the chair of the trustees and see if we can find something. Otherwise, it's impossible to understand what that was about. Can we now go in the Respondent's bundle to page 372? So this is this is after the cross-examination of the first defendant. And there are some exchanges going on before the next witness is called. And at E, the judge launches in on disclosure to Mr. Serafin. And this is, by the way, this is Schedule C63 of the Court of Appeals schedule, and my learned friend showed me. The judge says you are under an obligation to, you've not given proper disclosure in this case. You are under an obligation under the rules to give disclosure of all relevant documents. There are many documents which are relevant that I have not seen. Your failure to disclose them will give rise to an adverse inference. Do you know what that means? No. I will hold things against you. You should have disclosed things. It's only fair. The same would apply. Now, that is not the function of the judge. It's the function of counsel in an adversarial system, umpired by the judge, to make an application for specific disclosure. And the application for specific disclosure should have been made. I refer in terms of non-party disclosure to 3112. 3112 would have been the application for specific disclosure, and it would have to be tied to the pleadings, and it would have to be clearly demonstrated as to relevance, proportionality, and what exactly there was to be produced. It's not even told here, it's not even given a sort of list here as to what he should. The way in which disclosure had gone, I've already referred to when was exchanged in January. Following the exchange of witness statements on the 2nd of June, when the defendants were still represented, at that point the claimant was not, the defendants' solicitors wrote in August 2017 seeking further disclosure. It was on 9th of August. On the 23rd of August, when Simon Byrne, for the period when it was on the record, responded in detail on the 23rd of August, and further disclosure was given. There was then a pre-trial review before Mr. Justice Warby on the 5th of October 2017, by which stage the claimant was unrepresented. The defendants had their original solicitors and counsel. The only application in relation to disclosure was that the claimant's new disclosure provided by him in the August 2017 letter should be formally listed. There was no application for specific disclosure under CPR 3112. Now, I said I would come to the position in relation to Mrs. Serafin, and I'd like to start, we're going to come back to this, the transcripts bundle, in a moment, but if we could go first back to the judgment of the judge at 198, paragraph 198. 353. So at 198, the judge says, the engagement of Mrs. Serafin remains shrouded in mystery. The claimant says that there was a competitive tender for certain design drawings. In fact, he was emphatic throughout his evidence that any work she did was not design, and that the tender of Mrs. Serafin or that of her firm was the lowest. He was also adamant that it wasn't her or her firm, but that she was working as a team member for a Polish firm. However, no evidence as to how much she was paid or what she did has been provided. The fault for this evidential lacuna rests with the claimant. The imputation of nepotism, to the extent that this matters, has been made out. So this finding arises from the defense, paragraph 14.9, which is page 433 of Bundle 2. So paragraph 14.9.
I'm so sorry, I've got your page number wrong.
433.
Thank you.
Not sure about that, is it?
Yes.
Yeah.
It is, is it?
14.9. Yeah.
14.9.
Yes.
CV 2433.
Okay.
So the indictment, if I may put it that way, is this. The claimant employed his ex-wife, Anna Serafin, as the architect on the project to refurbish the entrance hall. This was a profitable contract, and her appointment occurred without an open and competitive tender process having taken place and at considerable cost to POSC. She had no qualifications or reputation in this country as an architect. No proper records or accounts were kept explaining why she was chosen above London-based architects, or how much she and or, I think that should be her company, were paid for their work on the project. The claimant abused his position as the House Committee manager and as a director of POSC by employing his ex-wife and or her company where other more suitable architects were available. Defendants will invite the inference that as his family was a close one as pleaded below, both he and his ex-wife benefited financially from her being awarded the contract. Now, if we go and just see what the reply said at page 466. It's 10.5. As to paragraph 14.9, the refurbishment of the entrance hall was carried out under the supervision of the previous chairman of the House Committee, Dr. Lalko, who designed and oversaw the modernisation. The claimant assisted Dr. Lalko. The internal work was carried out by a single maintenance man. The external work on the stairs was carried out by Pereira marbles proposed by Mr. Ruman, who was the surveyor for POSC. The claimant was not involved in this contractor's appointment. The only time the claimant's ex-wife did any work for POSC was when the claimant realised that, contrary to regulations, there were more technical drawings of the building. Mr. Ruman employed various firms to make drawings, but they were no good and never finished the job. The claimant asked his wife to help, and she recommended the firm in Poland. His wife worked on the team that provided the drawings. The claimant's involvement meant that the price to POSC of the drawings was the lowest of three competing quotes. He derived no personal benefit. The rest of paragraph 14.9 is denied, and in particular the allegations and or inference that the claimant employed his ex-wife and or her company and that he personally profited from the refurbishment are baseless and denied. Now, the claimant gave evidence in his witness statement, and so in chief, that his ex-wife had not been engaged by him or anyone else. He gave his evidence in accordance with what one sees in the reply. He wasn't challenged on that in cross-examination. And the defendants call their witness to this was Mr. Lazinski. So Mr. Lazinski is actually a critical witness on two aspects of the defense, and this is one of them. So if we go to Mr. Lazinski, we go to the transcript at page 403. And the relevant part starts at H, where Mr. Serafin puts to Mr. Lazinski, in paragraph 12, your own statement, you stated that at the general meeting, this is what you meant, that it was announced that POSC would be redesigning the entrance hall, and he then goes on at C to say, and later on you're saying the project will be completed by Mr. Serafin's ex-wife, who is not a UK qualified architect. So that was the witness to prove that particular of truth. And the witness says, yes, I may have mentioned it, yes. And then he says, I thought I was correct. And Mr. Serafin says, there's no mention in the AGM about that. Where you got that information from, that my ex-wife going to carry out any work in entrance hall. The witness says, well, I don't exactly know who was mentioning it, but there was a lot of gossip going on at the time. Gossip, yes, but I thought it was correct, but I wouldn't swear to it. There were gossips, yes. So the judge then says, I just want to check what the answer was. I'll read it back, and what he reads back to the witness is, there was a lot of gossip going on about your ex-wife. I thought it was correct. I wouldn't swear to it. Is that a correct note of what you'd said, sir? Thank you. And then Mr. Serafin says, but you're going further with that thought. You developed that, and you say that once the project was completed, I understood that Mrs. Serafin had selected the wrong stone in front of the steps. And the witness says, yes, I understood if she was involved in this because the stones were slippery and so on. And Mr. Serafin says, yes, that's absolutely right. The stones were chosen. You are absolutely right, it was dangerous, but unfortunately not by my former wife because she was never involved in the project. Do you know who actually redeemed that front of Posk? The witness says, no idea. What the company, and the witness says, I understood from what was going around in talking to people that she was responsible as an architect. It may be wrong completely. Now, the judge then says, can I be clear? And he puts a suggestion to the witness. Is this really what you are saying? That there was a lot of gossip going on. You knew one way or another that Mrs. Serafin was engaged to do something at Posk. You did not know what it was, but you assumed that she was responsible for the slippery steps. And the witness happily agrees with that. And the judge says, have I correctly got it? So a leading question which shifts the witness to salvage the fact that he has crumbled totally on the point that's in the defence and which he's called to give evidence on. And he explains, yes, well, Mr. Serafin was involved in a lot of work. This is the witness at F. I thought it may be true that lady may have been put forward, and so on. Anyway, at the bottom, Mr. Serafin says, thank you very much, I think that's good evidence, which I think he was entitled to crow about that. Then he says, do you remember what position I had in Posk at the time you're talking about? Because the witness just said, well, Mr. Serafin was doing lots of things. What was my position? And the judge leaps in, he stops the witness from answering the question, which might have revealed further hopeless memory by the witness. He might have said, oh, you were chairman of the trustees when he wasn't, or whatever. And the judge says, I do not think it matters what he remembers, because your position was at the time is a matter of evidence I have already received. Then so the judge, one could be saying he's protecting the witness, but he's obstructing the cross-examination. Then at D, the judge says, there is no evidence at the moment that your wife was responsible for the slippery stones. Mr. Serafin says, absolutely, there was no architects on that project whatsoever. Mr. Metzer said, I'm not sure we'd concede that far. We'd certainly accept that we can't establish it was Mrs. Serafin. Now, at that point, counsel, or at the end of this witness, counsel for the claimant would have got up and asked the judge to strike out that paragraph of the particulars of defence. But no, that doesn't happen. The judge doesn't suggest it, and the judge, as we saw in his judgment, goes on to make the finding at 198. Page 353, you look at this now through the prism of the cross-examination of Mr. Lozinski. The engagement of Mrs. Serafin remains shrouded in mystery. No, it doesn't. It absolutely doesn't. the evidence has been given by the claimant and not challenged. The claimant says there was a competitive tender for certain design drawings. Well, no, he said she didn't do any designing, and that the tender of Mrs. Serafin or that of her firm was the lowest. No, the Polish firm where she was part of the team did. However, no evidence as to how much she was paid or what she did has been provided. The fault for this lacuna rests with the claimant. The imputation of nepotism has been made out. So the case is shifted, the judge has shifted the case, and the defence of truth on that aspect is proven. I see I'm past my time.
Just.
Very well. We'll adjourn for the day's hour then and sit again at 10:30 tomorrow.